Okay, Professor, good afternoon, everyone, and for all the students that will start joining us eventually. It is an honor and a pleasure to have Professor Rothwell with us today. And as a quick warm-up to the session, as I always say, I'd like to present a short bio of our speaker today. Joining us today is Professor Rothwell, who's the Professor of International Law at the ANU College of Law under the Australian National University, where he has taught since July 2006. And his research has a specific focus on the law of the sea, international polar law, and the implementation of international law within Australia, which his 26 books very clearly are a testimony, and over 200 articles over his scholarship research that spans over 2 decades. There are book chapters and notes in international as well as Australian publications. Professor Rothwell has also recently authored as well as co-authored books titled such as The Law of the Sea in Southeast Asia, International Law in Australia, and International Law of the Sea. And a lot of contribution that Professor Rothwell has made also reflects in his diversified career, experiences, such as the general editor of the Australian Yearbook of International Law. He is also an editor-in-chief of the Brill Research Perspectives in Law of the Sea. Also from 2012 and 18, he was a rapporteur of the International Law Association Committee on Baselines under the International Law of the Sea. And the range of courses that Professor Rothwell has taught us includes and is not limited to law of the sea, the international dispute resolution, international law and use of armed force, humanitarian law, military operations law, and public international law. Thank you so much, Professor Rothwell. As I always say, it's an honor and a pleasure that you take out time for us from your busy schedule. And please, the floor is yours. I'll just be sharing my screen so that we can begin with the presentation. Thank you so much for joining us.
Thank you for that very kind introduction, and it's a great pleasure to be with you this afternoon to speak about a topic that I'm very passionate about, and as was indicated in that introduction, I've been working on in various formats now for nearly 30 years. Can I also just acknowledge the very challenging COVID situation that India is facing at the moment, and can I wish you and your family and loved ones all the best in terms of dealing with that very challenging situation.
Thank you so much, Professor.
So I think if we just make a few more clicks on this slide, the full title will come up. And so the question that I'm wanting to pose in this lecture is, does a special body of law apply to the polar regions? And this is a question that's been asked by legal scholars and researchers for nearly a century. And the answer that I'll put to you towards the end is that whilst general international law certainly applies in the polar regions, there are some very distinctive characteristics of the international legal regime that applies in the polar regions. So I think it makes for an interesting case study, but we can also learn from aspects of the legal regimes that apply in the Antarctic and the Arctic. So I'm going to speak about the two legal regimes separately, and then I'll draw some conclusions from the end. But just before we commence, I'm just going to make some general observations. So if we go to the next slide, this slide gives you an image of the Antarctic continent. And I guess the critical point to initially think about is that Antarctica is a continent surrounded by the Southern Ocean. And so to that end, the maritime dimensions of Antarctica are actually quite important. But then if we go to the next slide, Antarctica has been subject to a series of 7 territorial claims. And you can see the various claims that have been made to Antarctica on the slide. If we just click one more, the image will come up showing you the way in which those 7 claims have been asserted over Antarctica. Some of those claims are framed in historical acts of discovery. So if you've done some study on the international law of territoriality, you'll have some familiarity with the significance of the principle of discovery in international law, but also the further conduct of the claimant states in terms of not only discovering new land, but also proclaiming title over that new land, but also seeking to assert certain levels of sovereignty over that land. And there's some interesting dimensions about those 7 Antarctic claims. The claims originally asserted by Britain are ones which are the foundation for the Australian and New Zealand claims to Antarctica. The claims by Argentina and Chile are based on acts of exploration, but also proximity to Antarctica. And one of the really fascinating aspects of Antarctic territorial claims is that you'll see there that there's one sector, one portion of the Antarctic continent which has not been formally subject to a territorial claim by any state. So we have one part of the Antarctic continent which is unclaimed. It's commonly referred to as the unclaimed sector. And sometimes I suggest to my international law students it would be interesting to conduct an exercise to determine how it might be possible to assert a claim over that unclaimed sector. And if you think about it, it's actually the only portion of the world in terms of a continental area which has not been formally subject to any territorial claim. The other initial observation I'll make is that notwithstanding the very significant interests of the United States and the then Soviet Union in Antarctica in the period following World War II, neither the Americans or the Soviets formally made any territorial claim over Antarctica. That's notwithstanding also the fact that the United States has some of the most significant bases and conducts some of the most significant scientific research programs in Antarctica, including a scientific base which is located at the South Pole, the Amundsen Scott Base. So those are just some preliminary remarks about Antarctica. I'll return to talk about that in much more detail a little later. But let's just move to the Arctic, the next slide. And when we come to the Arctic, we have a series of continental land masses which are surrounded or which surround the Arctic Ocean. And so here, territorial sovereignty is not in any way contested to the same level as is the case in Antarctica. So we have 8 states which are recognised as Arctic states as such. 5 of those Arctic states have territories that directly adjoin the Arctic Ocean: Canada, Denmark, Norway, the Russian Federation, and the United States. So sometimes you'll see references to what's referred to as the Arctic 8, the 8 Arctic states. But this image that you can see here is partly one that seeks to depict the significant presence of ice in the central Arctic Ocean. And that's an important theme that I want to draw upon as we develop these points in a bit more detail. So the next slide poses this question that I've been wanting to address, and that is there a body of international law that's particular to the polar regions? If we just click on the presentation, it'll bring up the various different dimensions. Are there any particular international law rules that apply to territoriality in the polar regions? What about scientific research? Can we draw anything in terms of demilitarization in the polar regions? What about protected areas, principles of common heritage? And also, are there any distinctive principles that apply with respect to Indigenous peoples and governance? So those are some of the themes that I want to touch upon. Now, of course, not all of those themes or dimensions are relevant to the two polar regions. The most obvious one being that there are no Indigenous peoples at all in Antarctica, whereas there are Indigenous peoples certainly in the Arctic, and that's a very important point of distinction. If we just go to the next slide, the other important overarching issue that exists in the polar regions is the presence of ice. By definition, the polar regions are ones which experience polar climatic conditions, and we associate those polar conditions predominantly with large amounts of ice. In the Arctic, that's predominantly reflected in the ice that you find in the Arctic Ocean and in the adjoining sea areas of the waters adjoining the Arctic Ocean. And there are two types of ice that are quite important here. The first is what's called multi-year ice, and multi-year ice effectively forms as a result of constant snowfalls and the build-up of snow over many years in very, very cold conditions, such that the ice is very, very thick and can only really be navigated through the use of icebreakers. And certainly in the Arctic, there's been a history of nuclear-powered icebreakers to ensure that there's a capacity, certainly on the part of the Russians or the Americans, to be able to navigate through parts of the Arctic Ocean. The next slide, however, highlights the other form of ice that we are increasingly seeing, certainly in the Arctic, and that is what's called first-year ice. That is ice that has developed over a winter season, and by definition, first-year ice is much thinner. It's not as thick, and accordingly, it's much easier to navigate. And as the polar regions begin to warm, Arctic first-year ice is certainly melting much more rapidly than what we see in the case of older multi-year ice. And so the next slide just highlights a very important dimension, and this is particularly reflected in the Arctic, less so in the Antarctic, and that is the significant rise in Arctic shipping. And there's two forms of Arctic shipping that we are principally interested in. One is commercial navigation through Arctic waters, and that can take the form of bulk carriers, container vessels, vessels carrying LNG and other substances. And as you'll see in a later slide, this is generating a lot of interest in terms of the ability to use Arctic navigation routes to avoid having to pass through the Suez Canal in particular, and to avoid some more traditional shipping routes. So commercial Arctic shipping is certainly on the increase, and as a result of the melting of the ice, a lot of this shipping can now undertake navigation in the Arctic without the need for an icebreaker, and that's an important dimension. The next slide highlights another aspect, which is not so much of an issue at the moment, given the impact of the pandemic, but certainly we've seen a rise in significant tourism activities in the Arctic, and so cruise ships have become very common in certain parts of the Arctic, certainly in the Scandinavian Arctic and in parts of the Canadian and American Arctic. So large numbers of people are going into the Arctic regions on these cruise ships, and that raises issues in terms of what would arise if there was a major navigational incident requiring search and rescue and the recovery of one of these cruise ships, or in the case of other maritime disasters, the ability to retrieve persons involved in a shipping incident. So the phenomena of Arctic cruise ships and the interest in cruising activities in the Arctic is another factor to be taken into account, and that's also raising issues for Indigenous peoples in terms of pollution impact arising from the increase in Arctic cruise shipping. So the next slide just overviews some of the issues. I've alerted you to some of those already. The consequences of climate change and ice melt, and that has an impact not only on Indigenous peoples, shipping and navigation, but also fauna and flora. And of course, there's a lot of attention being given to the consequences for polar bears, for example. A lot of speculation about oil and gas reserves being subject to exploitation across the Arctic Ocean. And to that end, law of the sea issues have become quite relevant. And also some sovereignty tensions, not necessarily as a result of tensions over territory, but rather maritime issues in particular. Now, there is one territorial dispute in the Arctic. The next slide just highlights that, but it's a rather small dispute. If you just click on the next slide, yes, now we can see the feature that's in dispute is Hans Island, and Hans Island is located in the middle of the Kennedy Channel, which is a strait between Greenland and Ellesmere Island. Ellesmere Island is a Canadian island. So Hans Island is subject to a sovereignty dispute between Canada and Denmark, but this literally is the only territorial dispute of any significance that exists in the Arctic at the moment, and that's quite distinctive from the situation that I outlined for you previously that exists in Antarctica. So what are the sovereignty issues that exist in the Arctic? Well, as I've alluded to, they are principally maritime ones. So if we go to the next slide, we can see here a number of the issues that have arisen in the last 15 years or so, which highlight questions about the ability of Arctic states to not only assert maritime claims consistently with the Law of the Sea Convention, the 1982 UN Convention on the Law of the Sea, but also to assert claims which go beyond the 200 nautical mile limit of the continental shelf. And so in 2007, Russia planted a flag on the seabed of the North Pole. Now, this was really an activity that was undertaken to generate media attention. It had no legal significance as such, but it just did highlight some of the tensions and some of the different positions that states were taking towards these issues. In May of 2008, the 5 Arctic states, which directly front onto the Arctic Ocean, issued the Aleutian Declaration. And that declaration, which doesn't take the form of a treaty, was designed to highlight the framework of the law of the sea in terms of resolving some of these sovereignty jurisdictional questions for the Arctic Ocean. And in addition to the questions for the Arctic littoral states, there's also interest being expressed for navigation by non-Arctic states through the waters of the Arctic Ocean. China and Korea are most commonly talked about in that context. I think there's also some Indian interests that are beginning to emerge also. So the next slide just highlights the way in which Arctic Ocean claims may well be asserted. And at the moment, we're going through a process whereby the Commission on the Limits of the Continental Shelf, a body established under the Law of the Sea Convention, is seeking to identify the legitimacy of some of those maritime claims. Eventually, one of those states will be able to assert a maritime claim which extends over the geographic North Pole, and that will extend to an outer continental shelf. That doesn't mean to say that that state owns the North Pole, so to speak. Will probably have some symbolism associated with it, but it does highlight the contested and congested nature of the various maritime claims that exist over the Arctic Ocean. So you've already gathered from my remarks that certainly the law of the sea is an important aspect of the legal framework for the Arctic. So the next slide asks the question, well, are there examples that comprise a distinctive Arctic legal regime? So there are some very interesting examples of treaties that have been adopted that apply to the Arctic. The 1920 Treaty of Spitsbergen, which applies to the Svalbard archipelago. Svalbard is a series of islands over which Norwegian sovereignty is recognised, but the Spitsbergen Treaty is often said to create what's called a condominium under international law, where Norwegian sovereignty is recognised, but other states also have legitimate interests over the archipelago. The 1973 Agreement on the Conservation of Polar Bears is a very early initiative seeking to provide for protection and management of migratory species. And so it was quite symbolic at the time it was negotiated, especially given that it was concluded during the Cold War, where the Americans and the Russians and the Canadians were able to come together and conclude that agreement. So there are some examples, and quite innovative examples, of international legal instruments dealing with the Arctic. The next slide seeks to develop that in a bit more detail. So it is possible when you look carefully at the Arctic legal regime to say, well, yes, there are quite a number of instruments, internationally legally binding instruments that deal with aspects of the Arctic. And some of those ones that I'm thinking of here have been particularly negotiated over the past decade, such as the 2011 Search and Rescue Agreement, 2013 Maritime Oil Pollution Preparedness and Response Agreement, and a 2017 agreement on enhancing Arctic scientific cooperation. And then more recently, there's been a conclusion under the framework of the International Maritime Organization of what's called the Polar Code, which has a strong focus on the Arctic. And one of the goals and objectives of the Polar Code is to ensure enhanced safety and security of shipping operations in the polar regions, and to diminish concerns about potential significant marine environmental impact. However, what we can say is that there's no comprehensive treaty which completely governs Arctic affairs. And that's in significant contrast to the situation in Antarctica that I'll speak about a little later. So if the next slide just continues to pose this question for us, and that is, well, what international law applies in the Arctic? Well, I guess the first point to observe is that the Arctic is not distinctive from the Indian subcontinent, for example. It's not distinctive from Africa. It's not distinctive from Australia. Human rights applies in the Arctic as it does in those other parts of the world. The UN Convention on the Law of the Sea also applies in the Arctic. But my observation is that there are a few very specific Arctic-wide regional agreements. And so that's created some debate and discussion as to whether or not there's a need for a very distinctive Arctic legal regime, or whether or not the Arctic is lex specialis, whether it's so distinctive that you should say that there's a different legal regime that applies in the case of the Arctic, or rather we just say, well, as I said, the Arctic is just another region in the world and international law applies there. So let's think about this in a little bit more detail. So the next slide just highlights the principles of international law and territoriality. And interestingly, there's a very famous case decided by the Permanent Court of International Justice, the PCIJ, in 1933, which dealt with a dispute between Norway and Denmark over eastern Greenland. And one of the important aspects of that decision, which we look to even today, is that the PCIJ suggested that there may well be some distinctive aspects, some distinctive features that we associate with conclusively proving territorial sovereignty over polar lands, as that term is used, because of the inaccessibility of the polar regions. Now, of course, those comments were made by the Permanent Court back in 1933. Whether they apply as much in 2021 is a question that we might want to ask ourselves. There's also been some interesting approaches adopted to territorial claims in the Arctic. The sector claim approach is an interesting one. The next slide highlights that a little bit in the context of both land and maritime boundaries in the case of the Bering Sea and Beaufort Sea. And here you can see basically straight lines being drawn along areas of longitude and latitude, which effectively, in principle, extended all the way to the North Pole. But these principles that have been relied upon in terms of so-called sectors don't really have a great deal of weight or standing in international law. eminent international law publicists don't give them much weight, and certainly the International Court of Justice has never accorded these principles any great significance. The next slide just does highlight, though, a point that I've made before, and that is that the law of the sea certainly applies in the Arctic, and to that end, the Arctic states all played significant roles in the negotiation of the Law of the Sea Convention. Article 234 of the Convention is often referred to as the Arctic Article. It's a provision that deals with marine environmental protection over ice-covered waters. And so to that end, Canada and Russia have certainly relied upon Article 234 to develop certain particular provisions under their domestic legislation. Another point that I've already alluded to in the Arctic relates to questions associated with Arctic navigation routes. If we just go to the next slide, you can see that there are a number of potential important navigation routes that exist through the Arctic Ocean. The Northeast Passage is the navigation route that hugs the Russian coastline, and then the Northwest Passage traverses the islands that sit to the north of the North American continent and runs along the American and Canadian coast. And so as a result of the increasing impact of climate change, Arctic navigation routes, as I said previously, are gaining a lot of prominence. So the next slide highlights the fact that a number of countries have begun to express more and more interest in navigating through the Arctic, and China is certainly one of those countries that's been engaging in a range of Arctic navigational operations. And certainly from China's perspective, and also from the perspective of Korea, if they were able to access navigation routes through the Arctic, they would save considerable shipping time in terms of moving goods from that part of Northeast Asia through to Europe, and possibly even to the North American market. So the next slide just highlights the various different types of navigation routes. And you can see there that the depiction of the ability of China to use that Northern Sea route between China and Rotterdam in the Netherlands could, in principle, result in a significant saving of a number of days in terms of travel time. And no doubt, recent events concerning the vessel that was stricken in the Suez Canal will just go to highlight some of those issues and dimensions. The next slide just highlights the fact that we, from a law of the sea perspective, think about, well, are there particular choke points? The word choke point is one that's often used in the law of the sea to depict where you've got relatively narrow bodies of water where ships have to pass through bodies of water with land relatively close by. There are a number of these Arctic choke points, and of those choke points, the most significant is certainly the Bering Strait. It would be the body of water that vessels would have to pass through to certainly gain access to the Arctic Ocean from the Pacific, and certainly East Asian states would be seeking to use that navigation route through the Bering Strait. So the Arctic has got a number of adjacent important navigation routes. Once you get into the Central Arctic Ocean, your navigation is going to be challenged at the moment by the presence of ice. But the question is, of course, how much is that ice rapidly melting? So finally, on the Arctic, our next slide just highlights the question about, well, what exactly is the current governance regime that exists in the Arctic? And in 1991, a process began which initially had an environmental dimension to it. And then eventually, in the late 90s, we saw the development of what's called the Arctic Council. And that Arctic Council is a political body which comprises a membership of the 8 Arctic states. But in addition, there are a number of Indigenous non-governmental organisations that are also permanent participants in the Arctic Council process. And then you'll see there that in addition to those 14 permanent participants in the Arctic Council, there are 13 non-Arctic state observers. And one of those non-Arctic state observers is India. So India is clearly, by gaining this status as a non-Arctic state observer, has expressed an interest in Arctic affairs. The chairmanship of the Arctic Council rotates every 2 years amongst the 8 Arctic states. But there's a high level of sensitivity within the Arctic Council in that it doesn't deal with security issues in the Arctic, and predominantly its focus has been on environmental issues and seeking to achieve higher levels of environmental governance and management. So I'll leave the Arctic for the moment and now revert to talking about Antarctica in a little bit more detail. So if we go to the next slide, I spoke to you previously about Antarctica, the presence of the 7 Antarctic claims that have been made to the continent. But from a legal perspective, the most significant difference between the two regions is that in the case of Antarctica, we have the 1959 Antarctic Treaty, which was concluded in Washington in December 1959. And that treaty extends to the Antarctic continent and to the surrounding waters of the Southern Ocean. It doesn't extend to all of what's called the sub-Antarctic islands, however. That treaty, which entered into force in 1961, currently has a total of 54 parties to it. So that includes the 12 original states who negotiated the treaty, 17 states who are called consultative parties. These are states that have joined the treaty and because of their scientific credentials and engagement in scientific research in Antarctica, have a higher status. And then 24 non-consultative states who are basically signatories who have expressed an interest in Antarctic affairs but don't have a significant engagement in scientific research. Now, most importantly for our purposes, India became a signatory to the Antarctic Treaty in 1983 and also very quickly attained consultative status under the Antarctic Treaty. So India has been a very active state in Antarctic affairs now for quite some considerable period of time, nearly 40 odd years. And to that end, it has a special status in the treaty system because not only is it a consultative party, but it's actually a very long-standing consultative party, but it's not a claimant state in the same way that, say, Australia is. Some of the key provisions of the treaty are summarised there for you. The treaty seeks to demilitarise the Antarctic continent. In other words, military activities are not permitted. It seeks to place constraints on the active exercise of sovereignty, seeks to promote the freedom of scientific research, and places constraints on the active exercise of national jurisdiction. The limits of the treaty are reflected in the next slide, Article 6, and to that end, it just identifies the breadth, the territorial limits of the Antarctic Treaty, and it includes obviously the continent, but it extends to an area up to 60 degrees south latitude. Notice the reference to ice shelves. It's a very interesting provision where you actually have a reference in a treaty to ice. And so the next slide just highlights the Antarctic Treaty area, which you've seen in an earlier slide as one that encompasses the continent and the surrounding Southern Ocean up to 60 degrees south. Now, the Antarctic Treaty includes within it this fascinating provision, which is found in Article 4 of the treaty. The next slide, summarising that, and that basically seeks to neutralise sovereignty in Antarctica. So remember that the treaty was concluded with 7 states asserting territorial claims to Antarctica. So how is it going to be possible to resolve these issues? Well, the treaty basically says, well, we're not going to try to resolve these issues. But most importantly, while the treaty is in force, these issues are effectively neutralised. And so no activities that occur whilst the treaty is in force will strengthen or give to a state the ability to enlarge an existing territorial claim over Antarctica. So let me give you an example of that. So India, as a major scientific state in Antarctic affairs, has a number of scientific research bases in Antarctica, consistent with India's interest in Antarctic affairs, but India is unable, consistently with Article 4 of the treaty, to assert a territorial claim to Antarctica because that would not be consistent with the provisions of the treaty. If we go to the next slide, the Antarctic Treaty has become the basis for what's commonly referred to as the Antarctic Treaty System. So what do we mean by that? Well, it's a reference to the fact that the treaty has spawned or been the basis for a series of additional instruments that have been adopted over the subsequent years. And you can see that those treaties have had a focus on environmental management and environmental protection. So resource management in terms of the conservation of Antarctic seals and the conservation of Antarctic marine living resources has been a focus. But the 1991 protocol to the Antarctic Treaty, so adopted 30 years ago this year, has a strong focus on prohibiting mining activities in Antarctica, and that was certainly a major point of controversy in the 1980s. But in addition to prohibiting mining activities in Antarctica, that 1991 protocol seeks to provide for comprehensive environmental protection of the Antarctic continent. So the next slide just reflects that very simple provision in the 1991 Madrid Protocol, and that is that any activity relating to mineral resources other than scientific research shall be prohibited. So it's certainly possible for scientific researchers to engage in activities relating to mineral resources, exploration for different types of minerals that might be found there, but no commercial mining activity, no extraction of mineral resources are permissible. Now that's fairly clear in the case of the Antarctic continent, but there have been issues raised about, well, how far does that extend in the case of the Southern Ocean, for example. Is mining activity prohibited in the Southern Ocean? What implications does that have for the continental shelf? What implications does that have for the potential to engage in deep seabed mining in the Southern Ocean? What about the role of the International Seabed Authority that exists under the UN Convention on the Law of the Sea? So some of those issues are not quite resolved. Legally at the moment, they might seem to be issues for the future, but once again, matters associated with climate change, I would suggest to you, are beginning to focus more attention on some of these questions. The next slide just refers to the area of regulation under the 1980 Convention on the Conservation of Antarctic Marine Living Resources. This is a convention commonly referred to as CAMLR. And the focus here is predominantly, not exclusively, but predominantly on regulating fishing and other marine-related resource activities in the Southern Ocean. This area of the CAMLR Convention extends a little further north than the limits of the Antarctic Treaty, and so it does actually encompass some of the sub-Antarctic islands that sit to the north of the Antarctic continent. And so the next slide just highlights some of those distinctions between those two different areas. And that's an important point for Australia, because it means that in the case of Australia, some of Australia's sub-Antarctic islands fall within the reach and the remit of the CAMLR area. Now, the next slide just highlights a development that we've seen in the last few years, and that is the adoption within the framework of the Convention on the Conservation of Antarctic Marine Living Resources, a series of marine protected areas that exist adjacent to the Antarctic coast in the Southern Ocean. And the Ross Sea Marine Protected Area that was adopted a few years ago is a very prominent example of that. One of the largest marine protected areas in the world, in which there's a complete prohibition placed on certain marine living resource activities within that particular area. The negotiation of this initiative proved to be quite contentious within the Antarctic Treaty System, but eventually it received endorsement. So the next slide just highlights some of these interesting issues, and as was said in the introduction, I have a strong interest in law of the sea questions. So there's some interesting legal issues here about the interaction between the framework and the provisions of the Law of the Sea Convention from 1982 and the Antarctic Treaty System from 1959. And they revolve around matters such as the ability of those 7 Antarctic claimant states to assert maritime zones consistently with the law of the sea, but does the assertion of those maritime zones sit in any way comfortably with the provisions of the Antarctic Treaty? And as a result of that, many of the 7 Antarctic claimants have taken a very conservative position with respect to the assertion of maritime zones, not wanting to create controversy under the provisions of the Antarctic Treaty. So the next slide just highlights some of the contemporary issues. I've raised issues about maritime zones. Is it possible to enforce regulation of fishing with respect to third states? The answer to that is partly yes, as a result of the mechanisms under the CAMLR Convention. But certainly there's been some interesting disputes that have gone before international courts and tribunals about some issues associated with that. There's been some ongoing issues with respect to illegal fishing, so-called IUU fishing in the Southern Ocean, concerns about marine pollution, in the Southern Ocean, and as I said beforehand, some ongoing speculation and discussion as to whether or not the Southern Ocean could at any point in the future be subject to deep seabed mining. I spoke before about Article 234 of the Law of the Sea Convention, which I've reproduced in the next slide for you. And Article 234, as I indicated in my earlier remarks, was principally negotiated into the convention by Canada and Russia to deal with the Arctic. But this has raised some issues as to whether or not this provision could apply in the Southern Ocean and in the case of the Antarctic. And to that end, just look at those first two words in Article 234. They seem to be fairly simple words, but to be able to rely upon Article 234, you must be a coastal state. Well, clearly India is a coastal state, and Australia is also a coastal state for the purposes of the Law of the Sea Convention. But is Australia a recognised coastal state in the context of Antarctica? And that's where we have significant disagreements, because whilst Australia, New Zealand, the UK, France, Norway, Chile and France and Argentina have all asserted territorial claims in Antarctica, very few countries recognise those territorial claims. So there's a real question mark as to the existence of a coastal state in Antarctica. And so the ability to rely upon Article 234 in terms of marine environmental protection in the Southern Ocean is well and truly compromised in that regard. The next slide, however, does show that Australia has made submissions to the Commission on the Limits of the Continental Shelf, and in reliance upon recommendations from the Commission, has sought to assert a continental shelf beyond 200 nautical miles. Australia would say, well, in the case of Heard Island, Australia is the recognised sovereign over Heard Island, and I think that's a fair enough claim. And accordingly, Australia says, well, Heard Island is to the north of the Antarctic Treaty Area, and accordingly, Australia is entitled to assert a continental shelf beyond 200 nautical miles into that part of the Southern Ocean. So here you can see some of the controversies, some of the nuances that countries like Australia have put forward. There has also been some controversies on the positions put forward by Argentina and the United Kingdom in relation to equivalent claims of the Antarctic Peninsula. So I'm just going to come to my concluding slides now. So I've asked this question, is there a distinctive polar law? Well, you might be able to say that yes, there is, in terms of what international law's got to say about territorial claims, and what international law has to say about ice-covered exclusive economic zones. And here I'm thinking about Article 234. But really, these are general principles of customary international law. These are general principles of treaties. They just have some particular application in the polar regions. So ultimately, there's nothing that distinctive about these rules of international law in those examples. The next slide, however, develops this point in a bit more detail, and I've written on this with my colleague, Dr. Alan Hemmings. We've published a book called International Polar Law, which is a collection of papers published over many years looking at polar legal issues. But in our introductory chapter, we make this argument to say, well, we actually think that there might be some strong evidence of some distinctive aspects of polar law. And so some of those characteristics include what I've called sovereignty neutralisation. What do I mean by that? Well, soft sovereignty, where sovereignty is claimed and asserted, but not actively promoted, not actively engaged in. So it's a soft form of sovereignty as opposed to the traditional forms of sovereignty that we associate with territory predominantly around the world. We've also got good examples of strong scientific cooperation. I've given you examples of that under the Antarctic Treaty, to which India is a major contributor. And the 2017 Arctic Science Cooperation Agreement is a good example of that occurring in the Arctic. Certainly got strong examples of environmental management in the case of both Antarctica and the Arctic, and also international environmental shipping management through the distinctive provisions of the Polar Code. And then the final point I'll leave you with is, can we say something about the governance regimes that exist in the polar regions? And I think you can, because what we've seen here is quite distinctive approaches to regional governance, which I don't easily see duplicated in other parts of the world. Certainly in the case of Antarctica with the Antarctic Treaty, you have a very distinctive, very well-developed regional governance regime. And that's an example of a hard law framework. In the case of the Arctic Council and Arctic governance, you've got a softer law approach, but you do see some of these common characteristics: cooperation, scientific freedom, scientifically informed decision-making, the use of the regions generally for peaceful purposes, demilitarization, a growing focus on stewardship of the region, reflecting certainly in the Arctic the interests of Indigenous peoples, and a strong sense that certainly in the case of Antarctica, the region is one that's accessible and needs to be maintained for all humankind. So it's been a delight speaking to you this afternoon, and I look forward to any questions that you might have for me in the discussion that follows.
Professor, here. Well, thank you for your address, though, Professor. I just had one small question with regards to what you were discussing about Article 234. So, would the answer then be just to add the word adjacent, as you see in the convention in so many other places? Would the word adjacent solve the problem in terms of other coastal states claiming territory, or is there a finer or a more nuanced and complex answer to this?
Thank you for the question. Ultimately, it's an issue of the recognition of a state. And in the Arctic, the states are recognised. Yes, there is that small territorial dispute between Denmark and Canada, but the presence of states are recognised in the case of the Arctic. In the case of Antarctica, the states are not recognised. They're not recognised at any level of significance, so that there's a recognition of a coastal state. Now, let's make it clear, nobody is saying that Australia doesn't exist as a coastal state. Australia clearly exists as a coastal state. It's just that Australia's claim over Antarctica is not recognised. So it's the recognition of the territorial claim that compromises the existence of the recognition of a coastal state in that particular setting.
Professor, just to further the discussion, obviously, I think with the polar states, do you see there being a universal convention being formulated anytime in the near future, or do you see the strengthening of the regional cooperation as it exists today?
Yeah, thank you for that question. I guess one of the interesting observations to make is that there hasn't necessarily been a lot of cooperation between the polar states in terms of the making of international law. There's a recognition that there are these commonalities that exist between the two polar regions. But the two systems, if you like, the Antarctic Treaty System and a colleague of mine, Professor Eric Molnar, refers to the Arctic Council System. So if you look at the Antarctic Treaty System and the Arctic Council System, they both operate quite separately. They operate in parallel streams, but they really don't interact with each other. That's notwithstanding the fact that there are some commonalities in terms of major states. The United States, of course, has a significant interest in both the Arctic and the Antarctic, as does Russia. Norway is also a state which has strong interests in both regions. But I think the general position is that the issues of the governance issues of both regions are so distinctive that there's no real desire to blend the two. Nevertheless, that's why I've sought to extrapolate, to identify what I think are some of the commonalities that exist in polar law. And I think there's strong arguments to say that, notwithstanding the fact that the two systems really don't interact, there are in fact some common aspects and features that we can identify for those distinctive legal systems.
Thank you, Professor. Are there more questions? Professor, I mean, with your experience, and obviously you've dedicated your research and scholarship to exploring the polar law. One important aspect which what I have read or come to understand through my exposure to international environmental law is that with the geographical and the spatial distance with the Arctic and the polar states, I don't think that even in academic scholarship there is much consideration as well as dwelling upon how interconnected and impactful the role of the polar states can be. As even an understanding this entire scholarship around and this interconnectedness in terms of scientific research and how the entire, let's say, the discourse as well as of climate change that kind of goes around the polar states, especially in terms of understanding the tipping point, or whether it's fast or whether it's nearby. So I think your discourse, and discussion has been very enlightening for the students and as well as for young scholars such as us, so as to understand that beyond this spatial space that we occupy, there are bigger issues which are going to be connected and going to be relevant, in fact, in the international law, sphere. And this is not something that can be ignored. So this is just an observation and that I'd like to make on behalf of all the attendees here today. And also, the other thing is that the role that India is playing, again, it's just about the access to information, that you would have. So to learn that India is playing a significant role, especially for the polar cap, for the polar states, it also becomes extremely, I don't know, maybe an interesting avenue for the students to explore in terms of scholarship as well, or furthering a career in this, in fact, and not just maybe a conversation that we've had with you. So thank you so much for that. I would really acknowledge the effort that Ankit, the International Law Society at Jindal, has made, and Dr. Popovsky, where I'm assisting him in this course. Because we've had opportunities to have scholars like you, we've also been able to update ourselves in the controversies and the conversations that are happening around us. So it really is, we're really grateful to you, Professor Rothwell, for taking out time today for us and giving us a lot of perspective today. Thank you so much for that. And once I hope the situation improves, we can host you at our campus, which even we have not had an opportunity to see yet.
Thank you for those very kind remarks. And can I just once again congratulate the Jindal Society of International Law for this initiative. It's a very bold, but I think well thought through and developed initiative, and it's terrific that we're able to use the technology to engage with each other in ways that we perhaps didn't think as extensively about until really this last year. So a great pleasure again for me to speak to you. And India is one of these interesting pivotal powers in terms of the polar regions. As I said, it's got a very long-standing history in Antarctica, and it's also an observing state in the Arctic Council. And Indian scholars have certainly been looking at polar issues. There's a lot of focus at the moment on China in the polar regions, but I think that there's a lot of scope and capacity to look at the role of India also. So congratulations to all of you. A great pleasure to speak to you, and I look forward to hearing more on the success of the students in the program into the future.
Thank you so much, Professor. Thank you.
Thank you
Such
so
a delight.
Sorry to cut in. Sorry. Thank you, Professor. Thank you so much for your time and also your expert thoughts. We're